You're listening to Still Unanswered. I'm Maya Ellison. Today, the Scott Peterson case, one of the most watched and argued criminal trials of the early 21st century. It's a story with a terrible hinge. A pregnant woman disappears on Christmas Eve. Bodies wash up months later in San Francisco Bay, and the husband is arrested, tried, convicted, and, more than 2 decades on, still at the center of new legal fights. Why does this one refuse to settle into a single story? That's what we want to dig into. Joining me is Dr. Aaron Kwan. Aaron, welcome back to Still Unanswered.
Thanks, Maya. Honored to be here. This case, wow. It's complicated in the way so many high-profile cases are. Emotionally raw, legally dense, and tangled up with media spectacle. I'm ready to unpack it with you.
Good. Let's start at the beginning, the human beginning. Laci Peterson was 27, pregnant, due February 10, 2003. Family and friends describe her as outgoing, close to her mother Sharon Rocha, planning for her first child. Scott Peterson, 30 years old, worked in fertilizer sales, an avid golfer. They met in college at Cal Poly, married in 1997. On paper, a middle-class California family. But then December 23, 2002. The events that day are crucial and are also where much of the dispute lives. Scott says he left around 9:30 a.m. to go fishing at the Berkeley Marina. Laci remained home, planning to walk their dog, Mackenzie. At roughly 10:30 that morning, a neighbor found the dog alone, leash attached, wandering the street. That detail has haunted the case. Aaron, what does that detail look like when you read the record?
It's a tiny fact with outsized consequences. A dog alone with the leash attached implies, on its face, that the person walking the dog either vanished suddenly or someone staged the scene. The prosecution used it as a physical anchor to argue that Laci never left the house alive. The defense used it to say maybe she left and was abducted while walking the dog. The problem is, in practice, it's ambiguous. Dogs are unpredictable, neighbors have different recollections, and memory contamination happens fast. But jurors heard that image, dog alone, leash on, and it stuck.
Right. And then the affair with Amber Frey, November into December 2002, enters the public narrative. Amber called police on December 30 after realizing the man she'd been seeing was linked to the missing pregnant woman. Detectives recorded calls between her and Scott. Those tapes were played at trial and became a turning point for many. Aaron, how ought we to think about Amber's role in shaping both evidence and public perception?
Amber's role is twofold. First, evidentiary. The recorded calls establish that Scott lied about being single and later lied about being a widower, and show a man who, at least in voice, was pursuing a relationship while his wife was missing. Second, narrative. The tapes and Amber's testimony were profoundly damaging in the court of public opinion. People hear a man who can compartmentalize a relationship while his home is under a missing persons cloud and draw moral conclusions. Legally, lying is not the same as killing, but jurors don't live in a vacuum. They bring moral intuitions to the box.
Which raises a central theme, a case built largely on circumstantial evidence. The prosecution never had a murder weapon, no clear crime scene inside the Peterson home, no eyewitness putting Scott with Laci's body. Instead, the state offered a mosaic behavior, falsehoods, the boat, the bay, a homemade concrete anchor, fetal development testimony. Aaron, can circumstantial mosaics be enough? And what makes them persuasive?
Absolutely. Circumstantial evidence can be, and often is, enough to convict beyond a reasonable doubt. Courts have long held that a chain of circumstantial facts, when cohesive, can point unavoidably to guilt. The key is coherence and exclusion of reasonable alternative hypotheses. In Peterson's case, the prosecution wanted to show a coherent narrative. Motive, an affair; opportunity, he was nearby in the bay; means, he had concrete anchors at his warehouse and a boat he admitted using; consciousness of guilt, lies, cash, prepping to flee. For many jurors, that chain felt sufficient. But the strength of circumstantial cases depends on how well alternative scenarios are addressed and how robust the forensic connectors are. That's where many of the still unanswered questions live.
Let's go step by step through the sticks in that mosaic. Start with the concrete anchors. The prosecution found evidence of a homemade concrete anchor in Scott's Modesto warehouse and argued he made multiple anchors to weigh the body. The defense countered, with experts, that the evidence wasn't conclusive. How consequential was that piece?
It was central as a physical link to the bay dumping theory. Prosecution expert Robert O'Neill testified the anchor in the warehouse didn't match the concrete in the Peterson driveway, suggesting the anchor wasn't made from a single bag used for a driveway repair, contradicting Scott's explanation that it was a one-off. The prosecution used that to suggest multiple anchors existed and others went into the bay. The defense's concrete expert, Stephen Gabler, pushed back, saying differences could be explained by materials and mixing methods. In the end, no additional anchors were recovered from the bay, so the anchor evidence bolstered the narrative but wasn't a smoking gun. It's persuasive but also contested.
Okay, then the bodies. A female torso found April 13 near Richmond, lacking head, arms, most legs. A near full-term male fetus found April 14. DNA confirmed Laci and Connor. The prosecution emphasized location, near where Scott said he had been fishing. The defense said bay currents and drift are chaotic. Bodies can travel. How much weight should we give that geographic coincidence?
Geography matters, but it's probabilistic. The bay is large, with complex currents. The fact that the bodies washed up near the Berkeley area gave the prosecution a compelling link to Scott's claimed fishing location, but it's not unique proof. Forensic oceanographers and dive experts explained at trial that many objects thrown in the bay could end up washed ashore in nearby areas, and that bay conditions can make locating small items like anchors nearly impossible. So the location was a strong circumstantial pointer, but not dispositive by itself.
Let's pick up fetal development. The prosecution argued Connor's development was consistent with death around December 23, 24. The defense's fetal expert, Dr. Charles March, suggested Connor may have been younger or older, casting doubt on the timeline. Then there was a controversial typo in Dr. March's report. Remember that? It really became a problem for the defense.
Yes, this was one of those moments where a little error can balloon into credibility damage. Dr. March testified that based on his assessment, Connor might have been carried later into December than the prosecution claimed, suggesting Laci could have been alive after Scott left. But during cross-examination, prosecutors highlighted inconsistencies, a typo, an error that, perhaps unfairly, made jurors question his competence. That's the danger. A single error can undercut an expert's entire alternative timeline in juror eyes, even if the underlying science is genuinely uncertain. Forensic fetal age estimation, especially after decomposition in salt water, has wide confidence intervals. You can't pin it to a single day with great precision.
So we have ambiguous physical evidence, uncertain timelines, and a powerful narrative driver in the Amber Frey recordings. Add to that public perception. Scott's demeanor, some called it flat, unemotional, played poorly in media and likely in the courtroom. There's a lot to unpack emotionally, but I want to turn to the defense's burglary theory. the house across the street had been burglarized. Defense argued burglars could have confronted Laci during a walk, killed her, and then disposed of the body, maybe even framing Scott. LIPE has re-energized that line. How plausible is it?
Plausible, in legal terms, means it raises reasonable doubt. The burglary theory includes specific factual claims, neighbors reporting suspicious activity, a van later found burned, and alleged evidence of a blood-stained mattress linked to that van. If true, those facts could form an alternative narrative. Unknown perpetrators took Laci. But the prosecution argued the burglary timeline didn't match, and police initially treated that as a separate crime. Critics of the investigation say there was tunnel vision, a classic problem where investigators, once they form a hypothesis, in this case suspecting Scott, deprioritize other leads. The LA Innocence Project's recent discovery efforts aim to test whether those alternative leads were properly investigated or whether evidence was withheld. It's a critical inquiry because if significant leads were ignored, that undermines confidence in the verdict. But it doesn't, by itself, establish innocence.
Which takes us to the Los Angeles Innocence Project's involvement. In early 2024, they took the case, alleging constitutional violations, withheld evidence, and new leads pointing to burglars. They won limited DNA testing on duct tape found on Laci's pants and got post-conviction discovery. Aaron, how significant is this post-conviction work? Could it change outcomes?
Post-conviction discovery and new DNA testing can be game-changing in some cases, but the bar is high. The duct tape ruling is important. It's a chance to see if there's DNA from an unknown male or others that wasn't tested or was missed before. If robust, uncontaminated, and non-Scott DNA is found that ties directly to an alternative suspect in time and place, that could be powerful. But there are many pitfalls: contamination, secondary transfer, mixed profiles, and evidentiary gaps. The broader discovery LAIP secured could expose investigative missteps or withheld reports, Brady material, which, if proven, could warrant relief. But historically, post-conviction litigation is slow and often incremental. Still, the case is not closed in a final sense, legally or publicly.
A momentary interruption. I want to push you, Aaron, on something. There's a tension in cases like this between the idea that juries can convict on circumstantial evidence and the risk that they convict because a defendant is morally disliked. Scott was an unfaithful husband, he lied, he seemed cold. How often do you see juries equating moral failure with guilt? And is that a failing of the system or just human nature?
It's both. It's human nature to let moral judgments influence fact-finding. Juries don't operate in a vacuum. They bring life experience, emotions, and moral intuitions. The legal system attempts to mitigate this through instructions beyond a reasonable doubt and by requiring the prosecution to meet that burden. But when evidence is circumstantial and a defendant is easy to dislike, the line between moral condemnation and factual proof can blur. It's a perennial problem in criminal law. Some defendants are convicted because their character, true or perceived, fills gaps in the evidentiary story. That's why robust defense work and skeptical juror deliberation are so important.
Right. And juror issues are a thread in this story, too. Rochelle Nice, the juror who had prior trauma and didn't disclose it on the questionnaire, became a focus years later in motions alleging juror misconduct. The argument was she was potentially biased due to a past restraining order during a pregnancy. A judge later ruled she was careless but not deceitful enough to overturn the verdict. Aaron, in your appellate work, how persuasive is that kind of argument usually?
It's an uphill battle. To get a verdict overturned based on juror non-disclosure, you usually have to show intentional concealment or actual bias, meaning the juror lied to get on the panel and then demonstrated prejudice influencing the deliberation. Judges and appellate courts are often reluctant to allow verdicts to be undone on juror question answers unless there's clear evidence the juror acted knowingly and with the purpose of affecting the outcome. The standard recognizes jurors are human and make mistakes. In the Peterson case, the judge concluded her failure to disclose was careless, not deliberately deceptive. That doesn't make it feel right to some observers, but legally it's a narrow path to reversal.
There's also the 2020 California Supreme Court decision. It overturned Scott's death sentence because the trial judge had improperly excused jurors who opposed capital punishment without adequately probing them, but it upheld the convictions. That left him with life without parole after resentencing. What does that decision tell us about error, prejudice, and remedies in capital cases?
It tells us two things. First, procedural fairness in the penalty phase is critical. Capital sentencing has special constitutional protections, and any hint of improper juror exclusion can taint the death sentence. Second, the guilt phase was seen as supported by substantial evidence. The court found no reversible error affecting guilt. So the remedy addressed the sentencing process without reopening the question of guilt. In capital litigation, you often win small victories that are important, like vacating a death sentence, without changing the fundamental verdict. That's still meaningful because death is irreversible.
Let's step back and look at the broader media environment. This case turned into a 24/7 spectacle: CNN, court TV, tabloid shows. There's a clear comparison that needs to be made between the intense coverage of Laci Peterson and the relative neglect of other victims, like Evelyn Hernandez, another pregnant woman whose body was found in the Bay months earlier with far less attention. How much does media attention shape not only public perception, but investigatory resources and even legal outcomes?
Media attention shapes everything. It allocates resources in a way public pressure can push police to act faster, or, behind the camera, prosecutors to take cases to trial. And it can influence jury pools. Cases featuring a certain narrative, suburban family, Christmas Eve, beautiful pregnant woman, are more likely to ignite national interest. That disparity isn't just aesthetically unfair, it has consequences. Investigatory bodies have limited bandwidth. Media firestorms can drown out other cases. The Evelyn Hernandez comparison is a painful reminder that race and class shape whose tragedies get national sympathy and whose deaths spur sustained investigation.
And ethically, we as producers, reporters, storytellers have a responsibility too. We can't pretend entertainment has no effects. That's part of why this podcast exists, to examine not just what happened, but how we arrived at the version of events we accept. Let's talk about what's still unresolved. I'll name a few and ask you to react. 1. Did investigators adequately pursue the burglary van leads? 2. Were eyewitness sightings of Laci that morning sufficiently investigated? 3. Would modern forensic methods on the duct tape or other evidence change timelines? 4. Did media saturation unfairly shape the trial?
Good list. First, burglary/van leads. Those are now at the center of LAIP's work. If records show officers deprioritized or failed to follow up on leads that might point to alternative suspects, that's a serious problem. Whether it's negligence or tunnel vision, it matters. Second, eyewitness sightings. These are notoriously fraught. Memories of seeing a pregnant woman walking a dog can be contaminated by publicity, but they shouldn't have been dismissed without thorough investigation. Third, modern forensics. Yes, technology improves. DNA extraction methods now can sometimes recover profiles from tiny, degraded samples that earlier tests missed. The duct tape testing might reveal unknown DNA, but even if it does, interpretation will be contested. Is it from the killer, a bystander, contamination? Fourth, media saturation. Undeniably shaped narratives. Whether it rose to a level of constitutional prejudice is hard to prove, but it certainly made impartiality harder to achieve. Fifth, murder of a pregnant woman and her unborn child. This, especially at the hardiest one, unlike the murder of a van or a neighbor, this was the crime of a murdered mother. That grave left unresolved and impartial.
I want to linger on the duct tape question because it's a live lab angle. The judge granted limited testing on tape found on Laci's pants, small but potentially pivotal. If that testing reveals an unknown male profile, what are the realistic next steps? New trial motion? Exoneration? Or more litigation over admissibility?
Realistically, it would trigger new motions requests for hearings, perhaps a writ of habeas corpus if the defense can show the DNA is inconsistent with SCOP and probative of another's involvement. To secure relief, the defense must tie the DNA to a person or to a factual narrative that undermines the jury's verdict. Unknown DNA alone, without context, rarely exonerates. The prosecution will argue contamination or secondary transfer. The defense will argue it points to third-party involvement. Courts will probably order further testing, chain of custody reviews, and perhaps hearings. It's rarely a quick path to exoneration, but it can be a lever to get discovery and potentially a retrial if the results are compelling.
Let me ask about the role of innocence organizations more generally. LAIP took this case, which signals they believe a credible innocence claim exists, or at least that constitutional issues merit exploration. But innocence projects have limited resources and very selective case acceptance. Does their involvement lend credibility, or could it be seen as a strategic selection to raise profile?
Both. Innocence organizations evaluate cases for both factual innocence potential and for systemic problems, Brady violations, poor counsel, forensic mismanagement. Their resources are limited, so they pick cases they think have warrant for serious post-conviction review. Their involvement adds credibility that the case has issues worth probing. But organizations are also strategic. They want cases that may lead to change and that highlight systemic issues. That doesn't negate credibility. It just means the case likely has legal hooks, potential withheld evidence, alternative suspects, or forensic questions worth testing.
We need to talk about emotion. Sharon Rocha, Laci's mother, has been a pillar demanding justice, writing a book, never wavering in her belief Scott is responsible. And Scott's family has been steadfast too, insisting on his innocence. For people listening who follow true crime, how do we hold space for both the search for truth and the compassion for families on both sides?
We do it with humility. True crime can become a stadium where people take sides, but at the center are real human beings. Families of victims deserve to have their loss honored. Families of the accused deserve fair procedures. Legal scrutiny isn't an insult to victims. It's an effort to ensure the system is right. That's the tension, honoring grief while insisting justice be meticulous. Our role as listeners, reporters, and citizens is to respect both needs and avoid turning people into caricatures.
Amen. A short interjection. The story continues to evolve. In 2025, Scott was attacked in prison, an incident that thrust him back into the news cycle briefly. That alone shows, even incarcerated, these stories move in public space. But turning to jurisprudence, if a judge were to find Brady violations, suppression of exculpatory evidence, what would be the likely remedies?
Remedies can range. If a court finds a Brady violation and determines the suppressed evidence was material and favorable to the defense, it can grant a new trial. In other contexts, courts might order discovery, vacate a conviction, or grant a new sentencing hearing if the suppressed evidence impacted penalty. Materiality is the key. Would the suppressed evidence have created a reasonable probability of a different outcome? That's a high bar, but it's the correct one. The Constitution demands that prosecutors disclose evidence that's both favorable and material.
You've worked on post-conviction cases. Walk our listeners through, practically, what we might expect from ALIBI's discovery and testing in the next year. Are there likely public filings, more hearings, an eventual motion for a new trial?
Yes, expect a phased approach. First, forensic test results, duct tape DNA report, will likely be released or summarized in filings. Second, as LIAP reviews files obtained through discovery, they'll identify documents, lab reports, or witness statements that might have been underplayed. Those will form the basis for a Brady claim or ineffective assistance of counsel claim if defense counsel failed to pursue leads. Then they'll file motions, requests for hearings to present new evidence. The prosecutor will oppose. The court will decide whether hearings are warranted. It could take months or years. These are incremental, but sometimes can culminate in a significant ruling if the new evidence is compelling.
Let's play devil's advocate for a moment, Aaron. Suppose all the ALIBI testing comes back negative. No unknown DNA, no new leads. What does that leave us with? A conviction on circumstantial evidence? A resentenced man in prison? Families divided? And persistent public debate? Is that an acceptable closure?
It's an imperfect one. The legal system's goal is not emotional closure, it's legal correctness. If exhaustive testing and discovery fail to produce exculpatory material, courts will likely say the conviction stands. Some will accept that as justice. Others will feel unresolved. That's the nature of criminal adjudication. The system tolerates residual doubt because perfect certainty is rarely attainable. For families, that can be intolerable. For the legal system, it's a recognition of limits. It's why we keep testing, keep litigating, because sometimes new facts do emerge, and when they do, the system should be able to respond.
One more specific forensic question before we shift to broader themes: contamination and secondary DNA transfer. People often expect DNA to be an unequivocal truth teller, but you've said many times it's more complicated. Can you give a concrete example of how DNA on a piece of duct tape might not mean what a layperson thinks it means?
Sure. Imagine a piece of duct tape found on clothing. Years later, it yields a partial male DNA profile not matching the defendant. A layperson may assume, aha, third-party DNA. Someone else must have killed the victim. But possibilities include the DNA arrived via secondary transfer, someone who handled the tape earlier, contamination during storage or testing, the DNA belonged to someone who touched the victim innocently months earlier, or the DNA is a minor contributor in a mixture that can't be reliably assigned. Forensics has improved, and methods can sometimes quantify likelihood ratios, but interpretation still requires context. Where was the item stored? Who had access? Were proper controls used? That's why courts often require more than an unexplained profile to grant relief.
We've spent a lot of time on the nuts and bolts. Let's talk about the cultural reverberations. The Peterson case helped fuel the true crime boom. It's been retold in books, TV specials, and now new documentaries. Do you think that retelling helps public understanding of criminal justice, or does it distort?
Both. Thoughtful retellings can educate people about process, evidence, and the human impacts of crime. But retelling veers into distortion when it seeks drama over accuracy or simplifies nuance to fit a narrative arc. The risk is twofold: demonizing or idolizing actors in the story, and shaping collective memory in ways that later impede objective reassessment. Good journalism resists the lure of tidy narratives. It tolerates ambiguity. Our job as scholars, producers, and listeners is to demand that nuance.
Agreed. I want to return briefly to the comparison with the Evelyn Hernandez case. That story shows how race and class shape which tragedies become national obsessions. How should journalists account for that in coverage, both self-reflectively and in practical terms?
Journalists should be rigorous about proportionality and equity. Self-reflectively, producers should ask, who are we centering and why? Practically, newsrooms should allocate resources to stories that aren't sensational but matter, cases involving marginalized victims. Spotlighting disparities is itself a journalistic beat. True crime as a genre has the obligation to interrogate not just the crime, but the systems that determine attention and justice.
We're nearing the end of our time. I want to give you, Aaron, 2 minutes to summarize for listeners what you think are the most cogent, actionable truths about this case. What should listeners walk away believing about the state of the evidence and the significance of the ongoing investigations?
2 minutes, okay. First, the original conviction was built on a coherent, circumstantial case that many jurors found convincing. Affair, lies, location of bodies, and the anchor evidence were woven into a narrative of guilt. Second, that doesn't mean every piece was airtight. Fetal age estimates, lack of direct forensic linkage, and unresolved eyewitness reports leave real gaps. Third, the LA Innocence Project's involvement and the new testing are not gimmicks. They're part of the due process machinery designed to catch overlooked or suppressed information. Fourth, DNA results, even if they reveal unknown profiles, will require cautious interpretation. They're rarely a silver bullet. And finally, beyond guilt or innocence, the case is a prism for larger problems: media influence, investigative tunnel vision, and the unequal attention victims receive. Those systemic questions are as important as the verdict itself.
Thank you. That was clear. Before we close, I want to read a short passage from Sharon Rocha. This is from an interview years ago where she said, and I'm paraphrasing, that no court of law can take away a mother's certainty about what happened to her daughter. That line has stuck with me because it reminds us the legal record isn't the only record here. Families are living with their own truths.
And I want to add one small thing. Sometimes the legal system's ability to revisit evidence is its best humility. Cases like this test institutions, courts, police, journalists. They force us to ask, are we willing to look again, to let science and disclosure do their work? That's the through line of reform efforts.
We'll be following the duct tape results, the LAIP filings, and any new court dates closely. If anything shifts, we'll return. This remains a case where the story the public accepted and the legal record that exists are not perfectly aligned with unresolved questions that linger. That's why it's still unanswered. If you found this episode thought-provoking, please consider supporting Still Unanswered. Subscribe, rate, or share. We'll put links to primary documents and reading material in the episode notes. Aaron, thank you for your insight again.
Thank you, Maya. Thanks for having me. And to the listeners, stay curious and hold both empathy and skepticism in your hands at once.
This episode was produced by Still Unanswered. Our research drew on court records, contemporary reporting, and recent filings from the Los Angeles Innocence Project. Thank you for listening. We'll be back with another case that refuses to close. This episode was produced by Still Unanswered. Our research drew on court records, contemporary reporting, and recent filings from the Los Angeles Innocence Project. Thank you for listening. We'll be back with another case that refuses to close.